Good morning, everyone, and thanks so much for being with us today. I'm Karen McBride from the ILA Marketing Forum, and we really appreciate you taking some time out. I know what summer Fridays can be like in library land, so it's nice of you to spend some time with us on a really important topic. Before I introduce today's speaker and guest presenter, I'd like to just also let you know that we're cooking up something pretty cool for July and August as well. That's going to be a two-part series of roundtables focusing on everyone's favorite, the annual report. So we are working with three different libraries. We try to pick a variety of libraries in terms of sizes and communities and the format in which they distribute their annual report. So we're trying to work it out to be kind of a panel discussion in two different sessions the first one will focus on sort of the information gathering part of the process. How do you find the relevant numbers and the stories that are going to matter to your community? And then the second piece will focus on the actual design and production of the annual report and how it's distributed. So I hope that you'll mark your calendars for those and just watch for either an email invitation from ILA, or of course you can always check on our Facebook group as well. So enough about that. Let's focus on the here and now today. So it's my pleasure to introduce to you Sarah Benson, copyright librarian and assistant professor at the University of Illinois Library at the University of Illinois at Urbana-Champaign. I don't know about you. My first thought was, how do you fit that on a business card? So Sarah, you're going to have to tell us if your business cards are 3 or 4 feet wide, but I have strong family connections to U of I at Urbana-Champaign, so just saying it always makes me smile. And Sarah is here with us today to talk about copyright, fair use, and attribution. So thank you so much, Sarah, and it's all yours.
Thank you so much and welcome and happy Friday. So I didn't get a lot of thoughts from y'all about what you wanted to hear about. So I'm mostly going to be talking about fair use because I think that's one of the kind of harder sticking points in copyright. However, I do want to answer any and all questions that you have. So as I'm going through, if there's a question about something that I am talking about, feel free to post it in the chat, but I'm also going to leave plenty of time for question and answer at the end, because I think copyright, as we know, it runs through a lot of our work and comes up in a variety of ways. And so I can't always anticipate all of the questions, but I'm happy to answer them as they come. So just shout out. I always give a disclaimer. I am a lawyer, but I'm not your lawyer. So don't construe any of this as legal advice. I do have a law degree and a master's of law and an MSLAS. So that's another thing that I struggle to get onto my business cards. And I always joke that if I decide to get another degree, I hope someone gives me a good slap across the face first and says, please think about this. Do you really need just any more letters after your name? I think at this point, hopefully I'm done. We'll see. So you all write things in marketing, right? You're writing copy. Do you own a copyright? Well, there actually are a few considerations there, but somebody does, right? Because for works produced today, protection is automatic. So you don't have to do anything fancy. You don't have to put a copyright symbol on it. You don't have to register it with the Copyright Office to have a copyright. It's automatic once the creative work is fixed. So fixed means written down or recorded. And the creative part just has to be minimally creative. It doesn't have to be, a work of a masterpiece of art. So yes, a lot of the things that we do and create for libraries is copyrightable. The question is who owns it, right? And so if you are a staff member, full-time paid employee of the library, chances are the library might own it, not you individually. That's under the principle of this doctrine called the work made for hire doctrine. But that really varies. So at academic institutions such as University of Illinois, I'm faculty, and faculty at the university own their own copyrightable materials, especially for teaching and research. So it varies and depends on where you are, but if you're staff, if you're a full-time employee, the general rule is that it would be owned by the library. The bundle of copyrights lasts a long time, the entire life of the author plus 70 years, or for works made for hire, it's date of creation plus 90 years. So it's a long time. And what rights are included in copyright? The right to reproduce the work or make copies, the right to distribute the work, even on the internet. So just because you put something on the internet doesn't mean you're waiving copyright. That's actually one of your exclusive rights. The right to create derivative works. So fan fiction is an example of a derivative work of a piece of fiction and technically might violate copyright from the owner of the book. Performance of the work publicly and public display of the work. So all these things are bundled up into your exclusive right to your copyright. And then, of course, you have the right to license any of the above to third parties. And that's just a fancy way of saying contract. And we, of course, know that as libraries, we engage in licensing with a lot of materials, especially ebooks and journals, e-journal, electronic journals. There's a lot of licensing. And so a lot of times we have to read that licensing because if we're not careful, we could give up some of our rights, like our rights in interlibrary loan, our rights to fair use, because contract trumps the general exceptions in copyright. So it's very important to read those licensing agreements carefully and to make sure that you are reserving the right to fair use and the right to interlibrary loan and things like that. Okay, so we own copyrights, our library owns copyrights, but other people do too. And so how can you use other people's work in your work? And specifically, if you're doing marketing for the library, you want to incorporate copyrighted works into it. So what do? There are a few ways to use works because copyright lasts for such a long time. It's pretty easy to poke holes into. And here are some of the ways that we can get around, how we can exercise our right to kind of create new works. So first, of course, if something's in the public domain, we can use that work. That is when copyright has expired, right? Copyright doesn't last forever. And so if copyright has expired, then anyone can use that work. If there's a Creative Commons license on it, then you can use the work in accordance with the Creative Commons license. And I think, oh, this is going to jump right into fair use. So I'll go through these in turn. So what's in the public domain? It's a moving target, actually. So currently, pre-1926 works that were published in the United States are in the public domain. Now, you're probably thinking, Sarah, you just told me that copyright is life of the author plus 70 years. Why is it pre-1970, pre-1926? That's because back in the day, copyright terms differed. And back then it was a set 95 years from the year of publication. And so if you do some math and you add 95 to 1926, you're going to end up with, 2020. And at the end of the calendar year is when the works expires, or 2021, actually. My math is really bad. But anyway, you're going to end up with that. And it's a moving target. So next year on the new year, we're going to get more works. We're going to get pre-1927. So anything published in 1926. And this includes art, music, video, songs, all of these things, right? So it's pretty exciting and includes a lot of stuff. And if things are in the public domain, then have at it, right? You can use it for whatever purpose you want. So that's a great thing. Also, things that are in the public domain are things that are produced by the government within the scope of their employment. So NASA created a really awesome database of all their photos of outer space. And that by definition is in the public domain because it was created by, NASA employees in the scope of their employment. So there's a lot of stuff produced by the US government that you can use as well, like census data, census charts, NASA photographs, things like that. So it's good to know that government works are also in the public domain. So Creative Commons licensing, if you search creativecommons.org, you can find things in the Creative Commons, and CC0 works are works that are designated to the public domain that were created today. So that's great that you can use those. But if you find like a CC BY, that means as long as you attribute the work, as long as you cite it, you can use it for whatever purpose you want. And then there's a variety of different licenses. And as long as you abide by the terms of the license, then you can use the work in your work. And those licenses are always subject to fair use as well. So you'll see at the beginning of my slides, I have a license on it. This is a Creative Commons license right there. It says CC BY NCSA. That means it's Creative Commons licensed. I want attribution. So you'd have to say Sarah Benson, University of Illinois, and cite where you found the slides. And then NC means non-commercial. So I don't want these commercialized without my permission. And then SA means share alike. So if you use these slides, you can create derivative works from them. But when you do create a derivative work, you have to use the same license. So these slides would never become commercialized unless someone had permission from me. That's what that means. Let's get back to that. Okay. So there are copyright exceptions, of course, and then there's fair use, which we're going to talk about today. And then you can ask for and receive permission from the copyright owner. I go through this list in this order, and the reason is because when you do ask for permission, people are often going to ask for money in return, right? I mean, the whole purpose of copyright is to incentivize the creation of works. So we incentivize people by paying them money. And so I do encourage folks to consider these other options first, and even fair use, because I don't know about you, but I don't have a bunch of money sitting around waiting to pay licensing fees for things. So if you do, that's great. You can certainly jump to number 5, but also sometimes it's hard to figure out who to ask permission from, right? To figure out who the copyright owner is. So sometimes there are works we call orphan works where we just don't even know who owns the copyright. So you might run into those issues as well. One other thing I would share with you is I love this website. I think it's called Unsplash. Is it .org or .com? Hang on, let me quickly look. Oh yeah, it's .com. So unsplash.com is a cool website where there are professionally produced photographs that are public domain. So anyone can use them. They're really great. I use them a lot in like keynotes, speeches, and like online presentations and things like that, where I don't have to worry. I don't want to worry about copyright, but I want a nice, clean, professional photograph. So I recommend that as well. I know there are other sources of public domain things like Pixabay and the Noun Project and things like that. All right, so let's get into fair use. Where does fair use come from? It comes from the Copyright Act. So volume 17 of the United States Code, section 107. And in the preamble, it says the fair use of a copyrighted work for purposes such as criticism, comment, teaching, scholarship, or research is not an infringement of copyright. So a lot of things that libraries do, we do a lot of teaching. We do a lot of supporting of research, right? So we're squarely fitting within the purpose of fair use. But then it goes on and it says, we have to consider these factors when deciding whether something is a fair use. We have to look at the purpose and character of the use, including whether the use is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion we've used, and the effect of the use upon the potential market for or value of the copyrighted work. Another thing that I would point out with fair use is it always involves a risk assessment, because fair use is a defense. And basically fair use says you can use this thing without permission of the copyright owner if it meets these factors, right? But they can always sue you and you'd have to defend the lawsuit based on fair use. The reason I bring this up is because you really want to have a good faith fair use argument to make. If you're an employee of a nonprofit library, then you do have some amount of protection because the Copyright Act says that you can't be sued for large damages for good faith assertions of fair use. That's great. That means there's less incentive for someone to sue, but they could still sue and try to get an injunction, which basically says, stop doing this thing. The reason I bring this up is I don't know how many of you have heard of the Georgia State University lawsuit, but there was a lawsuit against Georgia State University for their e-reserves, and it was based on fair use, and there were no damages. There was no monetary damages involved. It was for an injunction, and this lawsuit lasted for 12 years. So I guess that's my point, is like you do have to do a risk assessment, even though there are no big damages involved. Like if the publishers or whoever is coming against you is really interested in getting you to stop doing that thing, then it still can be a costly loss. So anyway, and I'm not trying to scare people, because honestly, I think we should exercise our fair use rights. It's one of those things where you use it or you lose it. It's just good. You do have to do some sort of risk assessment. For instance, I know some libraries who have items by Martin Luther King estates, right? And potentially they could make some fair use arguments to use those things or digitize them. However, they know that Martin Luther King's estate is very litigious. So they choose not to exercise fair use. And that makes perfect sense. So doing some sort of risk assessment, always a good idea with fair use. So let's go through the factors. I hope you appreciate my humor and abbreviating fair use FU. Is just kind of funny. I do that with my students too. But the first factor is the purpose and character of the use. So the more educational the use, the more likely it is to be a fair use. The more commercial, the less likely. So even if you're marketing libraries, you're not marketing them for monetary value, right? You're marketing services to the community. That's still like a nonprofit educational use. So we're most likely going to be on the side of fair use on this factor. Then we look at the nature of the work, and courts kind of consider this the least important factor. So this really doesn't matter as much, but if it's a published or factual work, it's more likely to be fair use. If it's unpublished or creative, it's less likely to be fair use. So like if you're using like Harry Potter, that's very creative, right? So that's where that would weigh against fair use. The next part is the amount used. So did you just use a small amount, like a quotation? That's usually a fair use. If you used an entire book, you can't copy an entire book and put it on a website. That's not a fair use. Or they look at whether you use the heart of the work, the most important part of the work. So like a refrain of a song, right, might be the heart of the work. So that would be weighing against fair use. And this is a balancing test, so you're kind of weighing all of the factors. And the last factor that's really the most important one is how are you impacting the market value of the work, right? Are you replacing the market for the original work? That is less likely to be a fair use, or it's a substantially different market, right? You're not trying to sell Harry Potter at the library, right? You're trying to get people to come in and like engage with it and like learn things. That's a different thing. That's not, you're not replacing the market value. In fact, you're probably increasing it because people are going to come in, learn about Harry Potter, get really excited, and maybe even go buy some Harry Potter things, right? Or watch the movie or buy the book or who knows, right? Another thing to be aware of in fair use is that there's what I call factor 1+, which is transformative use. I call it 1+ because it stems out of the first factor, the purpose and character of the use. And it came from the Supreme Court in this case called Campbell versus Acuff Rose Music in 1994. And the definition of transformative use is one that alters the original work with new expression, meaning, or message. So this is when you like kind of use something, but for a different purpose. And the more transformative the use, the more likely it is to be a fair use. And so courts have looked at, this is kind of glossed over all the other factors. Like you're using the whole thing, but it's transformative, right? So the courts seem to say, oh, it's okay. Or, it's a highly creative work, but it's transformative, right? So it seems to impact all the other factors. So it stemmed out of a case involving the song Pretty Woman, and it was actually the lyrics to Pretty Woman. And the court kind of tried to make a distinction between parody and satire. Here they said the parodist claimed to quote from existing material is the use of some elements of a prior author's composition to create a new one that at least in part comments on that author's work. Why? Because, okay, parody is making fun of the original thing. Satire is just making fun of something else. And when you're making fun of the original thing, you've got to have the person like know what you're making fun of. It's like Saturday Night Live sketches, right? Where they're making fun of the sitting president. They're making a parody, right, of something that actually happened. And if you didn't know that they're making fun of the president, if you didn't recognize that, oh, this is the president, it wouldn't make any sense. It wouldn't be funny, right? So they're making fun of the underlying thing. And that's why you have to kind of steal some of the stuff, right? That's where fair use comes out of. It's like, you don't need permission to do this because you need the thing to make fun of it. And you're also, this is a totally different purpose, right? I'm not trying to tell people the history of what happened. I'm trying to make fun of it. So in this case, it was Two Live Crew using the lyrics from Pretty Woman to do kind of a parody of it, called Pretty Woman, but it had different lyrics like big hairy woman, you need to shave that stuff. It's really gross. I'm not going to like go into it. You can find it on YouTube if you want to listen to it. But anyway, at the end of the day, the court found that it was a parody and they didn't need permission to use those lyrics. So next case comes out, the cat not in the hat, the O.J. Simpson murder trial. Do you think that this is a parody making fun of the cat in the hat, or is this a satire making fun of something else? What do you guys think in the chat? It's got a picture of like O.J. Simpson with a bloody glove, right? You guys remember from his trial and everything. Yeah, you guys are saying satire, and that's right. And you know, I love how they wrote a parody on on the cover of the book, thinking like this is actually gonna work. No, the judge said you were lazy and you didn't want to come up with something new, so you just stole the cat in the hat, and so it's not fair use. That's what the court found in that case. But enter years later, Second Circuit and Cariou versus Prince, and not Prince the singer. This is Prince, the appropriations artist. He took this photograph on the left from Cariou, who went and took photographs in Jamaica for an anthropological study. And he made these art renditions, such as on the right, and sold them to the likes of Beyonce for millions of dollars and was sued, of course, for fair use. And in that case, the court said Prince's work could be transformative even without commenting on Cariou's work or culture, and even without Prince's stated intention to do so. Because there were a lot of cases where people are like deferring to what the artist said, like, oh, I meant to say this. And they said, listen, we're just going to objectively look at it. So now what's the test? We're back to the original language, right? It doesn't matter if it's a parody or a satire. We're just looking at whether you altered the original work with a new expression, meaning, or message, right? I mean, clearly we know from the Supreme Court that parody is the heart of fair use, because that was the first case. We know that. But even if it's satire, if it's commenting on something different, if it's got a new meaning or message, if it's not going to supplant the market value of the original, then courts are more likely to find it to be a fair use. So here are some examples, just to kind of clarify a little bit more. In the post, cat in the hat case studies, there was an ethnographer who wanted to do a study of the Grateful Dead and their concerts. And in this book, they wanted to use posters from the Grateful Dead concerts. And they went and asked the artist who made the posters, and they said, hey, can I use your posters? And the author said no. So they used them anyway, and they were sued, right? They were published, and the publisher got sued. And they defended it under fair use. And the court said it is a fair use, right? Why? Because the original posters were for advertising concerts. And the new poster use in this book, they're shrunk down, they're on timelines, they're when things are happening, and it's for historical context. Also, no one's going to put this book on their wall. It's a big book, but the posters are small in it. And those posters are still selling on eBay for like $150. There's no impact on the market value. And so the court rightfully found it was fair use. I got a question in the chat. So satire used to not be considered fair use, but now it is. I mean, essentially, yeah. essentially, right after the Supreme Court case, there was this distinction between satire and parody, and it's kind of gone away. I just, the reason I go through that example is just to show how cases have moved over time. And we've kind of evolved at this point to like just going back to original language, right? It's still important because when I see a parody example, I know that's squarely fair use, right? But if I see a satire thing, as long as it's not impacting the market value and it's commenting on something different, I still think it's a fair use. So the moral of this story is you can use your fair use rights even if you ask for permission and someone told you no. And the court specifically said that in the Pretty Woman case. And this is what happened. They asked for permission, they said no, and they did it anyway. But I will tell you, your likelihood of getting sued goes up, right? Because now they know you're going to do it. Jason says an anthology of posters wouldn't be the same, correct? Do you mean if someone just like, they're the regular size and they were just like, here's the posters? Depends. I say it depends because that same guy, Prince, who's the artist appropriation, he took Instagram pictures of young ladies from campuses and blew them up into huge posters and made that an art exhibit and argued fair use. So it depends what the court would say. But in that particular example, they were using them as they were writing about it, and they were smaller, and we know like thumbnail images are different than full images, so it all varies. Yeah, a coffee table type book. I mean, oh, you mean just like, oh, just here, look at these pretty pictures? I mean, it depends. It still depends. Yeah, it still depends because it depends on what the purpose is. Like there's a famous case right now that was about a museum doing an exhibit of, I feel like it was, I don't remember who the artist was, but and they had images that were copyrighted that they put in the exhibit that they didn't have permission to do, and they got sued. And they said, no, we need these images in the context of this exhibit because it's showing what was happening at the time, right? And they had it online and they had it in print and they had it in person. You could go see them. And the court said, yeah, like they need these photographs in their exhibit to show the context of what was happening. And so even maybe the music scene themed book or coffee table type book might be fair use. Might be. I mean, we don't have that exact case, but I feel like that museum exhibit is kind of similar. Now, the difference in the museum exhibit is that museums are generally not for profit, and maybe a coffee table type book is. However, this book also was for profit. I mean, I had bought a copy of it. It was maybe like $30. It was not a cheap book. So it all depends. A lot of it depends on who the court is, the judge, and where things are moving. I don't know how many of you have been following fair use cases recently, but there's a really fun fair use case going on right now about Andy Warhol and his art involving the actual singer Prince. And he used a photograph from a famous photographer who sat down with Prince, and he took it without permission and created a series of Warhol type art. And there's a debate going on because the court said it wasn't fair use, but then it got appealed, and now we're not sure what's going to happen. I actually think it was fair use, but we'll see. So another example, this one from libraries about the Hathi Trust. So the Hathi Trust Digital Library inputs entire digital copies of books and other materials. For copyrighted works, the general public cannot see the entire book, but can search for how many times a specific term is used in the work. So they can look and say, I want to see if this book is about Einstein. Does Einstein come up in this book? And it will say, yes, 99 times on pages 5, 10. And the court said that is quintessential fair use, because why? The purpose of the original materials is to read them, but here you're using them for research. You're not even able to read or consume. It's called non-consumptive use. You're not consuming the materials. But we are making multiple copies of those books, right? So the moral of the story is even using the entire work and making multiple copies can constitute a transformative fair use, because here different libraries such as University of Illinois are inputting the work into HathiTrust, and it's going to Google, and they're like fixing the OCR, and then it's going to Michigan where it goes into the database. So you have a lot of copies of this full book. Of course, they are protected. They're not just open to the general public. But yeah, it's still fair use, pretty big endeavor. So that was a lot. I have a video on fair use. If you go to go.illinois.edu/fair use video, I have a library guide. I have a few library guides that you can check out that go through a lot of other things. This is my email address, but I wanted to leave a lot of time for questions. Oh, so Donna asks, Andy Warhol's colorized Monroe is transformative. I mean, in that instance, I'm not sure if he may have had permission, or he may have actually had permission in that case. I mean, the reason that this case came up, the Prince photo, is that he didn't have permission. So I'm not sure about Monroe's photos, if he had permission to use them, but I mean, they also might have been fair use, right? Because what was the purpose of the photograph of Marilyn Monroe in the first place, right? Some of them might have been for advertising, some of them might have been movie clips, some of them might have been for different things. And then later he's doing this for art, right? Which is a different purpose. He's not doing it for advertising, or even like, what if he got it from a newspaper clipping? He's not doing it for news, for factual history. He's doing it for art. Interestingly, in the case with Prince, the court did say that both purposes here were art, right? One is an artistic photograph, and the other one is an artistic lithogram or print, right? But I personally think it's a little different. What advice do you have to anyone who is new when it comes to marketing and libraries? I mean, so there's also the ARL, the Association of Research Libraries, has a really great publication out there called the Code of Best Practices for Fair Use in Academic and Research Libraries, but it really could apply to any library. And I highly recommend that as a resource, because it talks about common practices for exhibits, and I think also for marketing, right? That things that they think are, generally speaking, fair use. So you don't have to kind of think it's hard, right? So one thing they talk about is, if you have something in your physical collection and you're trying to market it and you're using an image of it to show what you have to get people to come in and see it, that's classically a fair use. So there are a lot of examples like that, and they also talk about ways to like limit liability, right, and to do things that are less likely to be problematic, right? So that is something I would definitely direct you to if you're new to this. I'm gonna find it actually, and I'm going to send you the link. Yep. Okay, here you go. There's the link to, oops, that was private. I didn't mean to send it privately. Hang on. Okay, so there's the link. And I would, print that out and keep it nearby, because I think a lot of questions will be answered in there. You'll find yourself going back to it again and again. Okay, so someone asks, Harry Potter is a hot topic at our library right now as we plan programming around his birthday every year. And there's a fear of using the name Harry Potter anywhere, so we call it the party that cannot be named. I think that's cute. I do think you're being overly paranoid. Here's why. So that's more of an issue, to be honest with you, of trademark than copyright, because you cannot copyright short phrases or names. so Harry Potter is a trademarked thing, right? And trademark is all about preventing consumer confusion. So for instance, I can't start selling really badly made shoes that I make in my basement on Etsy and call them Nike, right? Because someone's going to get them and say, this isn't Nike, these are horrible. That's consumer confusion. You're not confusing anyone when you're just trying to do, an educational thing at your library about Harry Potter, right? And the other thing is there's a very similar thing to fair use. There's a very similar exception in trademark that's just like fair use. So if it's for educational use and things like that, then you can still use the term. And I know a lot of people get scared about that, but I would say I wouldn't be as scared. Although I still think it's cute to say the party that cannot be named. Oh, Jason says Warhol didn't ask for rights much. Yeah, probably not. Not. I still think a lot of what he did was, in my opinion, fair use. So I got a question. Can we have someone dressed as Harry Potter and say, come meet Harry Potter? I mean, I think that happens all the time, right? I mean, like, I remember, like, yeah, I mean, I think that happens all the time. I'm not an expert in trademark though, but I will send you somewhere where there's a lot of frequently asked questions that I trust about trademark. It's the US Patent and Trademark Office. And there's like a frequently, there are some videos and things like that. And there are trademark basics and frequently asked questions. And I think that's where I would send you with those types of questions. Because, I know a little bit about trademark, but I'm not the specialist on trademark. I'm the specialist on copyright. So our library will be trying to eventually showcase a lot of historical pieces we have from the city. Are there precautions you think we should be making before trying to create an exhibit? Oh, that's a great question because so state-owned things, like I said, are generally in the public domain, but city-owned things, it depends. So I can't say with clarity if the things owned by the city are copyright free. So that said, it doesn't mean you can't do it, right? So one thing I would say is like investigate the copyright status of the items. See if they are copyrighted, like if the city owns them, or if they're in the public domain. Because some things may be in the public domain, other things may not, and that it really varies because state law is different than federal law on copyright. So that's one. Two, you can forego all of that if you just think that it's a fair use and want to assert a fair use, right? And so you'd have to think about the purpose of the exhibit and all of those things. But I think thinking through it is important before digitizing and doing these things, because I like personally to include copyright information with exhibits like that. If we're digitizing a bunch of things, it's really helpful to the patrons if you know whether it's in the public domain or not, right? Because if someone else wants to use it, it may be a fair use for the library to use it, but it may not be a fair use for a patron to use it if they're doing it in, say, a movie or something like that. So it's a really good idea to try to figure out the copyright status first. Do your best. If you don't know, then you can always say, like, these are historical documents. They're used to document history here. We have included them under fair use. The library doesn't own these items, etc. I mean, our libraries don't own most items we collect, right? So that's not surprising, but it's just, I do see some, weird statements about, copyright library for these like things that they digitize. That's not right. Just because you digitize something doesn't mean you own the copyright on it. So yes, trying to figure that out, good idea. Got a question. We do a series on YouTube for pre-K kids. We got a copyright flag for a video in which our outreach librarian was singing, "How much is that doggy in the window?" Oh boy. Why would that not be included under a fair use for educational purposes? Yeah. So here's the thing about YouTube. They have these bots that are going to ding anything, right? Because they have to do that to maintain their shield of liability, right? They have to look for copyrighted stuff. So, and music is like one of the easiest things they find, right? It probably is a fair use, especially if you're just singing it and like just for kids. It probably is, but they're going to ding those things. So you can always respond, right? You can respond to those flags and say, this is a fair use and here's why. I mean, same thing for university things. Like if we get a flag on our website and we have something that's like an excerpt of something, we could also respond with fair use. Although I will tell you, there are a lot of people who just start asserting fair use for anything that they feel like is educational, no matter how much they've taken and no matter what the context. You can't do that, right? It is a nuanced thing. Like I said, with the 4 factors, like you have to think it through it. It's not just that anything educational is fair use, point blank, right? So one thing I would encourage folks to do is to maybe use a fair use checklist. And I'm going to send you that in a second here. So that can kind of document your fair use assessment. And you could even do this for that video and say we've done this, assessment and we believe this is fair use. So that would actually help you to do your analysis. All right, I'm looking for the next question. We create programs publicly for about artists and bands whose images are not past the public domain date criteria, like John Lennon or Chicago. Sometimes we need more than a thumbnail because we're creating posters and newsletters. There are very few, if no images available that seem to be okay to use. Yeah, we want our program subjects to be easily recognized. How do you include a picture of a public figure like this without the possibility of liability? So, I mean, I think that to me, that's that case that I was talking about that is very similar. It was a museum that was using, images of public folks and for their exhibit, and they got sued, and the court found that it was a fair use. I'm going to see if I can find a link to that case really quick because that, let's see. Okay, I think I found it. Let's see. Oh, it was the Met. It was the Met that won this case. Oh yeah, Frankenstein guitar photo. Well, here's let's hang on. Still looking for it. I'm just finding a bunch of other things about it, but here you go. So maybe look through that and you'll probably find that that's very similar. Yeah, it's an Eddie Van Halen guitar. So there you go. Look through that and you'll probably see that your case is very analogous to that. And this is what we do as lawyers, right? We find cases and we say, is my case analogous to that? Oh, it is. Then that probably means that it's my instance is a fair use as well. And I also think the ARL Code of Best Practices would speak to that as well. Great questions. Other questions? We have a collection of every yearbook of our local high school. Do you think we should be having the high school maybe okay any of that? Well, so that brings up other issues, right? Which is young people and their photographs, right? Is like, I do think that's a little bit different than like historical documents because you've got, it's just youth, right? I mean, they were young at the time. It's not a bad idea to go back and ask the high school like for permission to digitize. And the other thing that you'll come up with, what we have at our library is a takedown notice policy that I helped draft. And one of the things that we get maybe is like not even copyright related, but like someone will say, I have a stalker and I don't want this photograph online because my stalker will use it to find me or whatever thing, right? And sometimes people just don't want those things online for very different reasons than for copyright. And so we have in the past scrubbed the metadata so that that person's name doesn't pop up when doing like a Google search in those instances. Yeah, so privacy can come into play a little bit. it just varies, right? So we have those things come up with like a newspaper article, like local newspapers, and there's really no privacy in a newspaper because that's pretty public. However, we still were willing to work with the patron, like I said, and scrub the metadata just for them not being in danger. Yeah, I mean, a high school yearbook might be a little more issue of privacy than you know, a newspaper. But again, I'm not a privacy expert. I'm a copyright expert. So I can't really, I mean, that's why I would go back to the high school and talk to them about them. I'm going to try to find our takedown policy just in case y'all want to see that. Let's see. I have a hard time finding some of these things. Oh, policies for library users. So one policy that I'll share with you is our free and open online public domain reproductions policy, which basically says if something's in the public domain and we reproduce it, we're not going to charge you for it and we're not going to give you permission because we don't own it. But you can use it because it's public domain. So there's that. I helped draft that. There's also a policy, like I said, about takedown requests, and here's that. And you'll see that generally we say, hey, we're not going to take down things because, you know, our goal is public access. But if there's a really, if you are saying, hey, you're violating my copyright, like we want to know about it, or if you have some sort of privacy concern, we want to know about it, like if there's a health and safety concern. So feel free to look at those or borrow those policies if they would help your library in any way. Other questions? These are great questions. I hope I'm answering them sufficiently. I mean, I don't claim to be the expert of everything. You know, I know where my limits are, so I do the best that I can. But I mean, copyright is my area. Privacy is not necessarily, and then you know, trademark I know a little bit about. But feel free to ask. I'll do the best I can. I can send you to different resources for sure.
This is Tamara Jenkins with ILA. We have plenty of time, so please don't be shy with the questions. We'll give it about 1 or 2 more minutes, and then I think we'll wrap up.
Yeah, and if you don't have a question right now, I mean, I understand it's kind of putting you on the spot, but you always can email me. I get a lot of emails from outside of my library, and you know, we are a land grant institution. Part of my job is to help the public, and you all can, you know, I consider you part of not just the public, but like my colleagues, and I'm always happy to help. So you know, if you get into those doing the copyright review, for instance, of those city documents, and you're just not sure where to go or who to ask what the copyright status is, I've been doing a very similar project with a faculty member here on campus. So I'm happy to kind of help you navigate that. Oh, Jean says, I've been concerned about fair use after taking an online image copyright course. You put me in a little more ease. Yeah, it is. Yeah, okay. So I will tell you, copyright education really varies. And some people are like the copyright police, right? They're just like, you'll get sued. I mean, please, I don't want people to feel that way. I think that is not productive, especially if we're members of libraries, right? And educational institutions, because a lot of what we do really is fair use, and we do need to educate the public and do our jobs, right? And use images that we have in our collections to showcase our collections. So and it really varies who you're talking to, right? So if you took a class, let's say from the Copyright Clearance Center, the CCC, they have a very vested interest in saying that nothing is fair use or very little is fair use, right? Why? Because they are the ones you're paying for licensing fees. They want your money. So consider the source too. When you're getting copyright information, look at who's telling the information, because they may have an angle. I don't really have an angle because frankly, you know, I work with a lot of faculty who own their own copyrights. I own my own copyrights. Like I care about authors' rights just as much as I care about, you know, fair use and creative rights. And so look and see and make sure the information you're getting is balanced. Question, using an image of a DVD cover to advertise a free screening of a film for which we have a presentation license is okay. That should be fine. I mean, you know, as you know, Google reproduces images online through thumbnail images every day, all the time. And the court said it was fair use. And is Google charging? No, Google is free, right? Or sorry, hang on, is Google free? No, Google is making tons of money, right? And so, and we are free, right, generally. So what I would say is, you know, use a smaller image, don't use this huge giant image, right, and all those things, but that should be totally fine. Book cover for book club meeting. Yeah, we use book covers all the time in our, at least we do at our library for our LibGuides, right? We can import them directly in there. Again, fair use here. So I think that we shouldn't be quite as worried about those things. But yes, Google has been pushing fair use for a while, and they're certainly not free. You know about the Google Books decision. Now there was Google versus Oracle at the Supreme Court, and they won based on fair use. So, okay, question. Our library has a collection of a lot of older magazines. We would have to consult the magazine company before posting them online, question mark. I mean, depending, right? We just had we just digitized a bunch of old advertisements because again, think about the purpose, right? Advertisements are most certainly fair use. Why? Because when they came out in the magazines or whatever, they were to sell something at a very specific time. They're not even selling that product anymore. So if we publish them right now online for educational use and for historical relevance, right, that's completely different. We're not harming any market value because those things aren't being sold anymore. And they're definitely not being sold in that same way. And we have a media studies group, right? And these students would want to study those and other students. So there's a very good fair use argument there. So probably there might be a fair use argument for you, but then it depends on how old they are, right? Like if you're talking like, you know, the year 2000, that still might be relevant, right? They still might be making some money off of those things. So if you're just reproducing an entire magazine from the year 2000, you might be impacting market value. So that's what we're looking at is market value impact. That's usually one of the key considerations in digitizing. Are you familiar with the use of pop culture imagery and meme types communications that fall under parody? Oh, that's a really great question. Yeah, so I went after, I did a presentation about copyright, and right after me, a woman did a presentation about teaching in libraries and used a bunch of memes and was like, oh no, I'm gonna get sued. And I thought, what? I'm like, that's classic fair use, right? Because you're using the image for a different reason, right? And it's humorous and it's usually like a parody. So yes, I think memes are pretty clearly a fair use and that's what we've been using them for. And we don't seek permission, right? To use those images of whatever it is, right? Like I actually had my students, I used the example of Baby Yoda. I think we know it's called Grogu now, but like when Baby Yoda came out, Disney, who is notoriously terrible about copyright, tried to shut it down. All the memes, all the things, right? But people kept creating and creating and creating, and they couldn't keep up with the takedown notices. And I was like, yes, the users won because, you know, it's fair use. And really, Disney, you can't shut this down. Like you opened the floodgates of like everyone's Baby Yoda, like obsessed, right? And I feel like a meme is different. Now, some people are selling like homemade Baby Yodas on like, see, right? Well, that's potentially a trademark issue because they're also going to try to sell Baby Yodas, right? They're gonna make, they did end up making their own stuffed Baby Yoda. So that's an issue. You can't sell your own Baby Yoda. You don't own Baby Yoda. But, you know, creating a meme, you're not selling anything. I think go for it. Yeah, I'd say, and I actually had my students from the first day create little Baby Yoda memes. That was our assignment. Good questions. And also, fun fact is you cannot copyright short phrases, so, or titles. So you'll see books come out that have the same title as another book. And as long as there's no consumer confusion, as long as it's pretty different, right, then you can do it. You can use that same title. There's a graphic novel with the title "Are You My Mother?" And as you know, there's a children's book titled "Are You My Mother?" And I was in a presentation at ILA, and the author said, I used "Are You My Mother?" for this graphic novel, and wouldn't you know, did you know that you can't copyright short phrases and titles? And I yelled out, you know, but yeah, you can use that as long as you're not confusing people. So you can't copyright "You're fired." Right, you can't copyright it. You might be able to trademark it though, right? That's the difference. So there's trademark, but again, trademark doesn't protect the same thing that copyright does. Trademark says you can't use this thing in the same marketplace for the same purpose. So if it's different and you're not confusing consumers, then you can. Depends on how big, you know, the market is for that particular thing that you're trying to do. For instance, like Tiffany, Tiffany has a trademark on Tiffany blue, right? The packaging that they use. It doesn't mean you can't use that color. It means you can't use that color for a box to sell jewelry. Because if you do, people are going to be confused and think it's, I mean, if my husband gives me a ring in a blue box with that blue ribbon, I'm going to think, oh my gosh, he bought me Tiffany. And then I open it, it's this really crappy, you know, off brand. I'm going to be super disappointed. But if he tries to sell me like, you know, a tire for a car and it's in that big blue box, I'm not going to be confused, right? I'm not going to say, oh, is this a Tiffany tire? So that's the distinction. These have been really, really great questions. I really appreciate you visiting with me on a Friday in the summer. I hope you have a great weekend. I hope you don't get too hot. I've been really hot here in Champaign. It was like in the 90s. It's too hot.
It's been very hot up here too, Sarah, and we want to thank you for your time and all your expertise that you shared with us today. This has been really great. I know I was interested and heard a lot of useful things, and let you read all your rave reviews there. But we want to thank you again for your time and sharing all this great stuff with us today. Thanks to everybody who joined us this morning. Just a reminder, July and August, we'll be tackling annual reports in a two-parter with a panel group from a bunch of libraries. It's going to be really great, but thanks, and have a great weekend. Yes, stay cool. It is hot up here as well, and hot. I think the whole state of Illinois is just hot right now. So take care, and we'll see you all again soon.
Bye, everybody.